Perfect. See on here too? Or no? On the record, the matter of the people of the state of Michigan versus Cody McInnes, file number 23-02612. Council appearance.
Good morning, Your Honor. Richard James on behalf of Cody McInnes, who is standing at defense table to my right.
Jeff Broadway on behalf of the people, Your Honor.
Today was the date and time that was set for a preliminary examination. My understanding is that there's an unconditional waiver to the circuit court. Is that correct?
This would be waived, Your Honor. The people would be seeking, and I've discussed this with defense counsel, to be adding a count 2 to this to be waived up with to the circuit court, and that would be an added count 2 of controlled substance possession, cocaine, heroin, or other narcotic.
Somebody have the file. You can continue.
Okay, yes, it would be an added count 2 of possession of controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams, which is PAC code 333.74032A5. And the substance in question would be fentanyl, Your Honor. And so with that added count 2, yes, the people would be waiving their right to a preliminary exam and ask this be bound over to the circuit court on both charges.
Okay, and then Ms. James, with that understanding, your client's still waiving?
That is correct, Your Honor.
Okay, and Mr. McInnes, how are you?
Good, how you doing?
I'm doing well, thank you. You understand in this case, you have the right to have a preliminary examination.
Yes.
And at the time of the preliminary examination, you have the right to require the prosecution to meet their burden of probable cause. So they need to establish that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. You understand that?
Yes.
And you wish to unconditionally waive your preliminary examination?
Yes.
Is anybody threatening you to get you to do that waiver?
No.
Has there been any promises made to you in exchange for a waiver?
No.
And you're waiving with the understanding that they're gonna add an additional count of possession of a controlled substance?
Yes.
Okay. And you understand unconditionally, waiving means you can't change your mind later. Once this matter is waived, it gets bound over to the circuit court, there won't be a hearing here to establish probable cause. You recognize that?
Yes.
You signed this document?
Yes.
The bind over date is November 22nd. That's the date the circuit court get the file from this court. You do not need to appear in circuit court on November 22nd, okay? Your next court date in circuit court will be a pre-trial. Ms. James' office will be notified of that next date to stay in contact with them. Has your address changed since your last court date?
No, ma'am.
Okay. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from defense, Your Honor.
Bond will continue. You're all set.
Thank you, Your Honor.
No problem. Jean Joseph is downstairs.
Yes.
Okay, we can bring him up. And then where's Don? Not sure. We can find out what she wants to do with her client. If she's ready to do the waiver. On the record, in the matter of the people of the state of Michigan versus Jeffrey Bowers, file number 23-03227. FY, council appearance.
Jeff Broadway on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milton, on behalf of Mr. Bowers. Mr. Bowers has run down and put money in his meter. Thank you, Your Honor.
No, I wouldn't start with, she's like 3 cases. Ronnie Hodges.
I had
I
in
thought
my
I see
notes,
Mr. Raleigh, but he must have stepped up.
I had in my notes, Your Honor, from last week that Mr. Hodges was being treated as a PCC, being as he did not have an attorney last week. And he
Okay,
wanted to
well,
make a
I don't
field.
see I don't see the defense counsel in here, so you give me too much information. I just want to know if we were running.
Sorry. I believe that was being treated as a PCC.
It's not my docket says. Yeah, I see you never. I'm like, and Mr. Freeman, your client is in custody. I just had him go get him from downstairs.
I'm sorry.
Your client's Gene Joseph.
Yes.
I sent Mr. Bigelow to go get him from the jail.
Thank you.
No problem.
Now, Mr. Bowers is here.
On the record in the matter of the people of the state of Michigan versus Jeffrey Bowers in file number 23-03227 FY, council appearance.
Jeff Rado, it's on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Mills standing in for attorney of record Jared Austin, who has a conflict this morning. And I'm here with Mr. Bowers, who is standing to my right.
Okay, how are you, Mr. Bowers?
Thank you.
Today's the date and the time that was set for preliminary examination. I have here a plea offer. It says, the people are offering for the defendant to plead no contest to count 3 and an added count 4 of use of methamphetamine and added count 5 of use of narcotic cocaine ecstasy, in which case the people would dismiss counts 1 and count 2 and the second offense notice and habitual offender notice. Is that a complete and accurate understanding of the plea offer, Mr. Mills?
Yes, Your Honor, that is a complete and accurate.
Okay, and Mr. Bowers, that's what you understand your plea offer to be?
Yes.
And you want to accept that offer today?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Hand down, please. Okay. I have an advice of rights and plea information sheet with today's date on it. Did you read this document? Do you understand each of the rights here?
Yes, sir.
Do you have any questions about these rights? Is that your signature?
Yes.
Okay. And you're willing to give up each of those rights today in order to enter a no contest plea?
Yes, Your Honor.
Okay. And what is the reason for the no contest plea?
Intoxication, lack of memory.
You understand that you have the right to the presumption of innocence, so you're innocent until proven guilty. You understand that?
Yes, Your Honor.
You have the right to require the prosecution prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. And they do that at the time of a trial. You understand that?
Yes.
You have the right to jury trial, or you can have a trial by judge if you waive your right to jury trial. And at the time of your trial, you have the right to remain silent and not have silence be used against you. You understand that?
Yes.
You have the right to confront any of your accusers or witnesses called by the prosecution at the time of your trial, and you have the right to cross-examine or question them. You understand that?
Yes.
You have the right to call your own witnesses or present evidence that you believe further a defense to the charges being brought against you. You understand that? Are you willing to give up all of those rights today?
Yes.
Anybody threaten you to do that?
Yes.
There's many promises made to induce you to give up those rights.
Sorry.
Are you currently on probation or parole? You understand that a no contest plea could result in a conviction that you may need to report to your current employer or to a future employer.
Yes, Your Honor.
You understand a no contest plea could result in a conviction that may have impact on travel or immigration status that you may be seeking.
Yes.
As to count 3, which is domestic violence, do you plead guilty, not guilty, or no contest?
No contest.
And as to the added count 4 of use of methamphetamine and an added count 5 of use of narcotic, cocaine, and ecstasy, How do you plead? I have a police report from the Lansing Police Department, case number 23519106000. Indicates that on or about October 25th, 2023 at 4:04 a.m. Officers were dispatched to the area of 1336 Robertson Ave for a report of a fight that sounded like it was physical. Officers engaged with parties, last name Bowers and Jaquez, who had been married for 15 years. Bowers was taken into custody by officers to transport to Lansing City lockup. Officer stated that he placed Bowers in the front of the flag on the passenger's side back fender and conducted a search. While searching, the officer found a hard object in the lower left pocket of Bowers' search. Officers opened the pocket of his shorts and found 2 baggies of a controlled substance later identified as methamphetamine and cocaine. Excuse me. Also noted in the officer's narrative, the officer indicated that individual by the name of Alita stated that she and Bowers have been together for 15 years and have 2 children in common. Victim Alita indicated that the accused Jeffrey Bowers became upset over an incident with his cousin. The victim stated once the accused returned to the backyard, he took his anger out on her. The victim advised the accused pushed her out of the chair, causing her to fall to the ground. Officers were taken or took the accused, Mr. Bowers, under arrest on the scene. They double locked handcuffs and checked for tightness. Officers took custody of the below items from Officer Burkett and tagged them into evidence on the 4th floor of the Lansing Police Department headquarters. It should be noted that the officer making this report is True Narc trained, and there was True Narc tested 1 item of 4 grams of True Narc tested cocaine with packaging, and item 2, 3.5 grams of True Narc tested methamphetamine with packaging. Any additional factual basis?
Nothing, Your Honor.
No, the defense, thank you.
The court is satisfied with the factual basis and I'll accept your no contest plea as to counts 3 and counts 4 and 5, which were added, and enter a guilty plea by way of no contest plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing.
January 4th.
So what was the time?
9.
January 4th at 9 a.m.
Thank you.
When you leave here, sir, you need to go down 1 floor to the 5th floor to meet with our probation department. They'll get you checked in for your pre-sentence interview, and now they'll get you scheduled for the pre-sentence interview. I'm also ordering you to undergo a substance abuse assessment prior to your date of sentencing. So that needs to be coordinated when you go downstairs to meet with our probation department, okay?
Okay.
Do you have any questions?
No, Your Honor.
Okay, you can appear via Zoom for your sentencing. You do not have to. If you appear via Zoom, you need to make sure your audio and video work and that you're in a quiet space conducive to conduct an official court proceeding, okay?
Okay.
Do you have any questions?
No, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense, thank you.
You're all set, sir. We'll get you a copy of your notice to appear. This is Gene Joseph.
Yes.
Okay, on the record in the matter of the people of the state of Michigan versus Gene Joseph Jr., file number 23-03189, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Your Honor, Stephen A. Freeman, Assistant Public Defender on behalf of Mr. Joseph.
Okay, Mr. Joseph, today is the date and the time that was set for preliminary examination. I have a note here that there was an issue last week that needed to be flushed out, so we said we would treat today as another probable cause conference. Were you able to flush out the issue?
Thank you very much for asking, Your Honor. Yes, we made good use of this past week. I'd like to thank the court publicly for allowing us that extra time. And at the pleasure of the court, may I please indicate that I spent some time yesterday with Mr. Joseph at the jail. And I brought him copies of the statute. I brought him copies of the jury instructions. And it was my attempt to answer some questions that he had. All of that to say that we parted company yesterday with an uncertainty as to whether he was going to waive his preliminary examination. As of this moment, I don't know what his intentions are. I believe that's probably a decision for him, but I do not know if he's made that decision. If he has not, then I would, on his behalf, respectfully request an examining schedule. Thank you.
Okay, so Mr. Joseph, you're being charged here, count 1, armed robbery, maximum penalty life for any term of years. Count 2, armed robbery, maximum penalty life for any term of years. Count 3, armed robbery, life or any term of years. Count 5, weapons, firearm, possession by felon, 5 years and or $5,000 is the maximum penalty. And then count 5, weapons, felony, firearm, maximum penalty. Two years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. There's a count 6 and a count 7 and a count 8, all felony firearm. Again, maximum penalty 2 years with and consecutively and preceding any term of imprisonment imposed for the felony or attempted felony conviction. You also have an habitual offender 4th offense notice. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 6, 2017, he was convicted of domestic violence 3rd offense and a violation of MCL 750.814 in the 30th Circuit, and that on June 7th, 2018, he was convicted of uttering and publishing in the 56th District Court, and then on June 7th, he was also convicted of resisting and obstructing in the 56th Circuit Court of Eaton County. So that would enhance the primary offense penalty to life if the penalty was 5 years or more, and 15 years if the or less if the primary offense had a penalty of under 5 years. Your primary offense has a maximum penalty of life or any term of years. And so, sir, you have the right to have a preliminary examination here in the district court. The purpose of that preliminary examination is to require the prosecution to bring forth evidence to satisfy their burden of probable cause. So probable cause is more than mere suspicion that a crime was committed. So they need enough of that evidence to say that there was a crime that was committed and enough of that evidence to say you're the person suspected of committing that crime. Do you understand that? Is that a yes?
Yeah.
Okay, and so you would have to waive that right if you didn't want them to have that, but that's your right to waive. Your attorney can't waive it for you. And we are here to make sure your rights are protected. So if you want to hold your exam, that's all you need to say. If you're not sure, you can say that too. We'll give you more time to think about it and consult with your attorney off the record, okay?
Not sure.
You're not sure what you want to do right now? So I think it's best that you have more time to consult with your attorney, because it is a short time period between the time that you're arraigned and today's date. You have the right to have your exam within 21 days of your arraignment, but sometimes that's not enough time. And so you not being sure what you want to do right now, are you willing to waive the timeline so that I can reset this? Okay, you're willing to waive the timeline and I can give you a new date so you can think about having your exam?
Yes, ma'am.
Okay, and no one's threatening you to waive the timeline, sir?
No, ma'am.
Okay, so I'll enter your waiver of the timeline only, and we'll give you a new date. We'll get you a new probable cause conference and a new exam, and that way you'll have sufficient time to think about how you want to proceed, okay?
New PCC November 22nd.
Your new
at
PC
1.
new PCC will be November 22nd at 1 p.m.
And then exam will be December 7th at 9:30.
Your new exam will be December 7th at 9:30. You have any questions at this time? Okay. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you very much.
Thank you. You're all set. We'll get you a notice to appear, okay? Let's see. Mr. Etheridge,
Yes, Your Honor.
I don't know if there are clients here.
I don't think she was written out in Clinton County.
Okay, so we'll reset that matter. Let me see.
And I wanted to give the court an update on the drug court referral and maybe get some guidance from the court.
Thibodeau. On the record in the matters of the people of the state of Michigan versus Kaylee Thibodeau, I have file numbers 23-01343 FT and then 23-02379, council appearances.
Jeff Redos on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Derek Etch, Office of the Public Defender, on behalf of Ms. Thibodeau for the felony, and Mr. Lee from our offices in the courtroom as well, and he has her misdemeanor file.
Okay, thank you, Mr. Lee, your appearance, please.
Assistant Public Defender John Lee on behalf of Kaylee Thibodeau.
Thank you. And today was the date and the time set for a pretrial and a preliminary examination. However, Ms. Thibodeau was in the Clinton County and for some reason she was not ready here. So we are proceeding with this portion of the hearing in her absence. Mr. Etheridge, you had an update.
Yes, Your Honor, an update, and wanted to seek some guidance from the court. She was in Ingham County Jail until about around 10:31. This was a specialty court drug court referral. Ms. Taylor attempted to contact her at that jail and she was no longer there. She assumed she was bonded out, but when I checked, I determined she was in Clinton County Jail. I provided that information to Ms. Taylor so she could hopefully be able to complete the assessment with her being at Clinton County Jail. I asked for an update yesterday and I was advised by Ms. Taylor that Clinton County Jail refuses to allow her contact with the client by Zoom in order to do the drug court assessment. So I don't know if the court could rid her back over here just to do the assessment, or if this happened in the past, what the court did.
I can't say that I've dealt with this before, but I'm happy to rid her here for an assessment.
All right, Your Honor, I'll contact Ms. Taylor and try to get a date from her that should be available and then let Ms. Addie know.
Okay, very good.
Thank you, Your Honor.
I'll note that here in the file, we've already addressed the timeline on the felony, so no need to do that. And I will just set a control date so that we don't lose track of these matters. You can set it as a review.
December 15th at 8:30.
December 15th at 8:30.
Thank you, Your Honor.
No problem. Any additional matters on these files today?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set. Okay, Mr. Raleigh. Oh, I should probably have Mr. Text and Hodges up. Mr. Milks, did you have another matter?
No.
Oh, okay, right.
What, speed? I do.
Are you covering for Austin?
Yes.
Okay,
He's still on trial. Battery's lying.
okay, sounds good.
That sounds like it.
Attorney for Stephen Williams present?
Yes.
Okay, on the record in the matter of the people of the state of Michigan versus Stephen Williams, file number 23-00434. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Stephanie Kornbeck on behalf of the defendant Stephen Williams, who's here present to my right. Because we withdrew our plea last time, Your Honor.
Oh, okay, because of, that's what I'm saying, I have a sentencing file, that makes sense, okay. Okay, and are we running our exam today?
At this time, Your Honor, at least when I came into the courtroom here, I'm not aware that the complaining victim has appeared here in court today, Your Honor, or the responding officer, so I believe the people would be unable to proceed at this time, unless they've, shown up in the last half hour or so and have not made their presence known to me.
I'll let you go and double check. You can have a seat right there. Okay, it's being transferred.
Yes, Your Honor, you're still on the record here.
Yes, we
Okay,
are.
yeah. Yes, Your Honor, after checking the hallway and the jury room, it's my understanding that the complaining witness and the responding officer have not appeared, so the people are unable to proceed at this time.
Counsel, how do you want to proceed?
I would like to ask for a dismissal, Your Honor.
Motion to dismiss without prejudice is granted. That simply means the case is dismissed today. The people do have the right, however, to reissue the charge against you if the necessary witness re-engages with the prosecution office, okay? Okay, do you have any questions at this time?
No, Your Honor.
We'll get you a copy of the dismissal, okay?
Thank you, Your Honor.
No problem. The record in the matter of the people of the state of Michigan versus Jabril McCullum. File number 22-01756. Mr. McCullum, you can come up to the table. Okay, Mr. McCollum, today was the date that I'm addressing a probation violation. You were supposed to be here November 6th at 1:30. Where were you?
I never checked my PO box, so I never got the mail.
You gave us a PO box to give to your mail? That's not what I have here.
It's probably the address on Edgewood. That's the address there, but I got a PO box outside, so all my mail that's going to Edgewood go right to my PO box. I just haven't checked my PO box in weeks. I didn't think that it would be a violation in it, you know?
You didn't think there was gonna be a violation in there?
No, man.
Well, that's interesting because the allegation is that you violated the terms of your probation by committing the following technical probation violation. Allegedly, you tested positive at EverHealth on October 5th for cocaine with a result of 573 nanograms. You didn't think there would be a violation coming if you weren't told that by your probation officer?
No, ma'am. I seen her on the last month on the 10th, and she
didn't tell you that she was gonna issue a violation?
no, ma'am. I do not know if she had got the test results in yet, but when I had talked to her, everything was
Okay.
fine. So when I had reported yesterday, Wednesday, she had told me then, like, we had issued a bench warrant. And I'm like, look for what? I'm not understanding. She said that you tested positive. I'm like, what?
Well, that's the allegation at this time. We haven't proven that. And you have the right to have a contested hearing to address this violation. You have the right to be represented by an attorney at that hearing. If you're found to be in violation, which this would be the third alleged violation, and the third violation alleging cocaine use. If you are found to be in violation, your probation can be terminated. You can be sentenced to a term of jail time or additional treatment. Do you understand that?
Yes, ma'am.
Are you requesting public defense office to represent you for the violation? What's your phone number?
517-528-6232.
You're still living at this address on Edgewood?
Yes, ma'am.
So enter a plea of not guilty. At this time, we'll set this for a hearing. You need to appear in person for the hearing.
Yes, ma'am.
November 27th, at 1:30.
It'll be November 27th at 1:30. Do you have any questions at this time? Have a seat, we'll get you a copy of the notice to appear, okay? Once we get you that notice, you go back down and see your probation officer. We'll get Mr. Bigelow to take you down there, so you have a seat there, okay? Who wrote this one? Let's. She can't.
I'm saying that she signed in the blue pen right there.
You said what?
So she signed in the blue pen, so I'm just assuming.
Is Mr. Hodges?
Yes,
On the record in the matter of the people of the state of Michigan versus Jesse Hodges, file number 23-03251. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Rowley on behalf of Mr. Hodges.
Hi, Jesse Hodges, how are you? I'm doing pretty good. Okay, so today was the date that was originally set for a preliminary examination. Mr. Bigwell left me a note that he was running, but my note in the file definitely says that last week he didn't have an attorney. He was appealing the denial of a public defender. So we were supposed to treat this as a probable cause conference. And he's currently now represented by the public defense office. So is it that you intend to run an exam in the future? Is that what it is?
Yes, Your Honor. It is.
Okay, and so we will need to get a new date, and I'm going to find good cause to go beyond the 21-day timeline because of the fact that you had to appeal to get an attorney. So you had the right to have a attorney represent you in this matter. And then you also have the right to have your preliminary examination within 21 days of the date that you were arraigned. So you were arraigned on October 2nd. That's correct? Yeah,
I believe it was the 26th.
he's arraigned on the 26th.
Yeah, October 26th.
Okay, I just can't read the handwriting on here, that's why. I was gonna say that's well beyond 21 days. Okay, I see now, you were arraigned on October 26th, and your matter was scheduled for a preliminary examination today at 9 a.m., but due to you having to appeal to get an attorney, took a little extra time. I'm gonna find good cause to go beyond the 21 days, so I can set this for an exam, okay? November 22nd at 9:30. Do you have any questions at this time? Bond was set at 10,000, 10%. That will continue. Any additional matters at this time?
Just quickly for the record, Your Honor, so that it's on there, I did give to Mr. Rowley an offer, or extend to Mr. Rowley an offer today, and that would be for Mr. Hodges to plead to count 1, which would be stalking aggravated with a habitual offender second offense notice enhancement. The people would then dismiss count 2, count 3, and the habitual 4th offender notice, Your Honor. So,
That'll be noted in the file. Any additional matters for today's record?
nothing for the people.
No, Your Honor. Thank you.
Okay, you're all set. Thank you. Let's see, Mr. Miller. And well, we need Mr. Speed too. Bring Mr. Speed first. Okay, Ms. Donnelly, do you have Mr. Lawrence with you?
Yes, I do.
On the record in the matter of the people of the state of Michigan versus Douglas Edward Morris, file number is 22-01038 FD. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Douglas Morentz, who is present standing to my right.
Okay, how are you, Mr. Morris?
Fine, thank you.
Okay, today was the date set for a preliminary examination. My note was that the defendant was to be screened for sobriety court. Is that still happening?
Well, the offer was for the defendant to be screened for sobriety court. I believe last time we were here, the defendant wanted more time to consider that offer. I'm not sure if he is going to accept that offer. So screening has not begun yet, Your Honor.
It's not on.
And I would leave it to Ms. Donnelly for that.
Your Honor, yes, after discussing it with Mr. Morentz and the offer for sobriety court, if he does it, he will get the benefit of an OWI second offer. With that, Mr. Morentz would be comfortable with being screened for sobriety court. So we'll continue. But we can either find good cause to waive the timeline, or he can waive it himself, and then we'll have him screened, Your Honor.
Okay, so you do want to be screened for sobriety court?
Yes, ma'am.
Okay, so you understand, sir, that you have the right to have a preliminary examination within 21 days of the date of your arraignment?
Yes, ma'am.
You were arraigned on October 26th, so that's why you were set for a preliminary examination today, but due to your wanting to accept the offer to be screened for sobriety court, are you willing to waive the timeline to have your exam so that I can set this out to a further date so you can be screened?
Yes, ma'am.
Okay, anybody threatening to do that?
No, ma'am.
Okay, give me, it's the holidays, give me a date in January.
January 4th at 8:30.
Set this to January 4th at 8:30.
That's set for a review, Your Honor, or preliminary exam.
We'll set it for preliminary exam. Do you have any questions at this time, sir?
No, ma'am.
Any additional matters for today's record?
Nothing from the people, Your Honor.
No for defense.
Okay, you're all set for today. We'll get you a copy of your notice to appear.
Thank you.
No problem. And then, Ms. Donnelly, for Trevor King, I just signed that order,
Okay.
so that should be taken care of. He's not present today, is he?
No, he got a new job.
Okay. I just wanted to make sure that he wasn't waiting. The person who's out there sick, who's he waiting for?
That's Darian Summer Hour, Your Honor. I am ready to proceed on that. It's my understanding, I wasn't here at the last hearing, so
He's supposed to be.
I was gonna say.
Yeah,
No.
he's
yeah, with,
1 second on Mr. Summer.
Okay, I don't think he's on my docket. Okay, is this Mr. Speed?
Yes, ma'am.
Okay, we're on the record in the matters. Oh, we're not on the record because I don't have a court reporter. Where is she? She's gone for a little bit. Let's see if we can find her. Okay, you can be seated. Okay. Now we're on the record in the matter of the people of the state of Michigan versus Hakeem Speed. I have file number 23-03228 and 23-03301. Yes, please.
Jeff Brodowitz on behalf of the people, Your Honor.
Morning, Your Honor. Stephen Milks, standing in for Jared Austin, the attorney of record, both of us from the Lincoln County Defender's Office, and I'm representing Mr. Speed for today's hearing.
Okay. Today was the date and the time that was set for a preliminary examination. And my understanding, they might be in warrant status right on both of these files. I'm not sure. How was he taken into custody and not? Oh, he could not be arraigned due to intoxication. That's what it was. No, I was trying to understand how he wasn't arraigned. Broken spawn and still be arraigned. You couldn't arraign him due to intoxication, so he needs to be arraigned.
Has he since been arraigned? Because we've got a date for the PCC day and then as well as a preliminary examination on.
No, I revoked his bond. And that's my note here, because there was a bond violation that I couldn't arraign him on.
Okay. I see.
On November 2nd.
So.
No. Okay, so the allegation here in the PA 53 is that he violated his bond because he allegedly was told not to commit a crime and committed a crime while released. That he also was told not to use alcohol and he used alcohol, and that he also was not to possess a firearm and or a dangerous weapon. The allegation is that he had a firearm and or a dangerous weapon. And that he had interaction with law enforcement on November 1st, 2023. It said Speed allegedly committed trespass, which resisted instruction an officer, malicious destruction of property. He had a strong odor of intoxicants emitting from his person. and that he had a hunting rifle in his possession, arm length away in the same unit he was located. And so we attempted to arraign him on the second, but he could not be arraigned because of his level of intoxication. The other concern I have here in this file, I think that the GPS tether notified us that his tether battery had died on the first, but at this point, okay, at this point, he just probably had contact with law enforcement when it died. So the GPS tether violation is not going to be addressed. And so you have the right to have a contested hearing on that objection. You have the right to be represented by an attorney at that contested hearing. If you're found to be guilty of violating your bond, the bond can be revoked and you can be remanded to the custody of the jail pending these matters. Or you could be sentenced to a term of jail time as a contempt of court for violating a court order. That maximum penalty is 93 days in jail and or $7,500 in fine. Do you understand that, sir?
Yes.
Okay, so pleading not guilty to the violation.
That is correct, Your Honor. He is pleading not guilty to the violation.
We'll set that for a hearing. Okay, and then as it relates to the underlying matters, there's a new police officer assisting assaulting, resisting, obstructing. That's in 23-003301 FY, and then we have the possession of meth and police officer assault in 23-03228. Are we continuing to examine these?
I have in my notes, Your Honor, that because of that Mr. Speed picked up this new charge, I believe either day or night before the scheduled PCC last week, that this was being left on for preliminary exam, but would be treated as a PCC.
Right.
And the people have last week made an offer for Mr. Speed to attend drug court in that matter. And in the new file, which would be 23-03301 FY, the people would make the same offer of drug court, and that if Mr. Speed were to attend, were to be screened for and attend drug court, that a global resolution to both of these files could be worked out in drug court, Your Honor.
Okay, and I know Mr. Milch, you're actually filling in for Mr. Austin, who's in trial.
Yes, Your Honor.
So I don't know if you were aware of that offer, but I'm sure you'll note that and make sure your colleague is aware of that.
Yes, Your Honor. I was made specifically aware of this. Mr. Austin kept me updated as well. We would just ask if the court would consider setting the preliminary examination or another PCC, whichever is best, for the bond violation, these two cases as well, for same day. I think about 3 or 4 weeks is about what it may take for an assessment.
Minimum, with there being a holiday in the middle of this because of Thanksgiving coming. So hopefully it'll be done in 3 or 4 weeks, but it may take longer. Nonetheless, I'm gonna find good cause to go beyond the timeline on both of these matters due to our inability last week to address the PCC and arraign him on the alleged bond violation. And so I can adjourn that for a new PCC and that file, and then the new file, which has today set as a probable cause conference. I'll find good cause to go beyond the 21 days on that so that we can set these for the same date and have him screened if that's what he wants to do for drug court.
Yes, Your Honor. Thank you.
Yeah, give me a new PCC date. Say that again.
December 28th at 8:30.
December 28th at 8:30. And we'll set up a preliminary examination later if necessary.
Thank you.
No problem. Any additional matters for the record today?
Nothing from the people, Your Honor.
And nothing from the defense. Thank you.
You're all set, sir. And then I think the last one I have is Ms. Donnelly Miller.
In summer.
I don't have that on my docket. I don't
Oh,
know.
that's, yeah.
It's not mine.
He's scheduled.
That
On
was-
Judge Ward's docket.
Yeah, we can address that. too.
I can't address it because I don't have the case. The schedule is, if they're taking the case and he goes before Judge Ward, not for me. So it sounds like they've taken the case already. Did they schedule it for him? For them?
If they scheduled it before, it's today.
He's scheduled before-
9:30.
That's summer hours.
He's scheduled before Judge Ward today. Not me. It was at 9:30. They do know he's here, right?
Yes, he showed up in their courtroom. first.
Oh, okay, yeah. So
Yeah.
he should probably do that down next to them. Facts. Thank you. We'll have Miller brought up.
One second, I'm trying to find this call. I think are they doing that on the record with her?
I'm not sure.
He asked for a new date, so it sounds like they're gonna schedule.
Oh,
it there.
it sounds like they're gonna schedule it over there, I suppose. What date are we gonna do?
In December, the end, 28th.
December 28th or,
Yeah. The 28th.
yeah,
Yeah, that'll be fine.
Okay.
I'm not going anywhere.
December 28th. Works, yeah. They can put it on the record over there. They have to file, I think.
Okay. What time?
10:30. 10:30.
Okay. All right. So you have them go print off the notice then?
Yeah, they were asking us for a new date
Okay.
that works,
All
so
right,
they
I
can
will-
set it. But he's bringing, I don't know if they're doing it right now. He's supposed to be bringing Miller up right now.
Yes, he is. Yeah, he should be here any moment. That's over 5 minutes ago.
I'm just kidding. Well, thank
Do you have a law enforcement waiting for you? Who are you waiting for?
Yes, they're witnesses on the.
For Miller? Oh,
Yeah.
okay.
What's on motion?
Oh, I don't know. I just wanted to make sure. Yeah. Run very stupid.
Mr. Bigelow, while you were away, and Mr. Milks wanted to let you know that he's rooting really hard for your team this year.
Which one?
Thank you.
Oh,
We want to hear it on the record.
The Cubs?
Who?
The
He's already got his remand gloves
I
on.
panicked, yeah.
My baseball game, sir, is not the Chicago.
Just gonna check my jail first.
Your jail for, you have public defense counsel in there.
Yeah. I mean, go pay Pat.
Say, who? Patties? Say it.
Patriots.
Thank you.
Man,
Thank you.
You know, the jail refuses to take me. So that's baseball.
The Red Sox. Red Sox. Okay. And they didn't play off this year. Yeah. Well, I'm a Tiger fan, so like, tell me about it. I know. And the 2014. Yeah, there's a bunch of them. JD Martinez.
I don't need them.
The World Series. there's a bunch.
Oh, okay, that was
There's
my
Granderson,
fault. Was I supposed to
yeah.
put this in the file?
One
It had a 2-0 punch.
Is that the email from Heather?
From Heather.
Oh, that was just the
Oh,
time.
okay, sounds
And who was already.
She emailed.
Oh, yeah. Right, Steve?
I like Joanne Fabrics.
Okay, all right. Well, you could make a blanket or something like that. You could make a blanket or something. Keep that hold out. Are you ready?
Yeah, we can, are you like? Have a nice long weekend, Judge.
Have a good one.
Thank you, Judge. Good to see you.
You too. Okay, we're on the record in the matter of the people of the state of Michigan versus Josiah Miller, file number 23-02787, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
and Assistant Public Defender Sarah Donnelly on behalf of the defendant Josiah Miller, who is present and standing to my right.
How are you, Mr. Miller? I'm sure. Okay, today's the date and the time that's set for preliminary examination. I have a weapons discharge from vehicle, malicious destruction of property, 1,000 to 20,000, and 2 counts of felony firearm. My understanding is that there's an unconditional waiver of this matter to the circuit court. Is that correct?
Yes, Your Honor.
And negotiations are going to continue at circuit court?
Yes, Your Honor.
Okay, and the people are waiving their exam?
Yes.
Okay, so Mr. Miller, you want to waive your examination?
Yeah.
You understand the purpose of the examination?
Yeah.
Okay, so the purpose is for you to require the prosecution to meet their burden of probable cause. So probable cause is more than mere suspicion that these allegations of crimes will happen. They need to establish sufficient probable cause that a crime was committed and that you're the suspect who committed these crimes. You understand that?
Yes.
Okay, and you're willing to unconditionally waive your examination?
Yes.
Anybody threatening you to do that? Has there been any promises made to entice you to want to waive your exam?
No.
And you understand unconditionally mean you can't change your mind later, you're not waiving it in exchange for anything, you understand that? Okay. Your bind over date's November 22nd. That's the date the circuit court will get the file from this court. It's not the date you need to appear in circuit court, okay? Your next court date in circuit court is going to be a pre-trial, and they'll set that date after they get the file. Ms. Donnelly will be made aware of that and she'll be in contact with you, okay? Okay, and the address you gave us was on Rio Road. Is that still accurate?
Yes.
The phone number ending in 7260?
Yes.
Okay, bond was set at 5,000, 10%. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for defense.
I'm gonna have you sign this first before you leave. Need a pen? Oh, she has one.
What do you need to send you?
Additional matters for the record?
Nothing from the people, Your Honor.
Not for defense.
Thank you, you're all set.
Oh, yeah, you got.
Yeah.
Okay, yeah. Make sure. Oh,
So it's
yeah,
coming up
yeah, okay.
On Monday.
Yeah, let's not forget about that.
Yeah,
Is it set for Monday?
for final.